What if the last words a man ever spoke were, "I did not kill your son"? Not a plea, not a breakdown, a statement. Calm, final, irreversible. Now imagine, years after the needle goes in, after the body goes cold, after the family has buried their grief twice over, evidence surfaces. A witness admits they lied. A fire scientist says the arson never happened. A second suspect's name appears in a file that was always there, waiting. The state cannot give back what it took. There is no appeals court in the afterlife. There is no retrial for the dead. In the United States, execution is supposed to be reserved for the most certain cases, the ones where doubt has been burned away completely, where justice is not just done, but seen to be done. But what you are about to watch is the story of 14 people who were strapped to a table, injected with poison, or electrocuted, while evidence that could have saved them was ignored, suppressed, denied, or arrived just too late. Some of these men and women maintained their innocence until their last breath. Some had witnesses who recanted. Some had scientists who came forward. Some had courts that looked at the new evidence and executed them anyway. This is not a story about guilt or innocence. This is a story about a system so committed to finality that it decided certainty didn't matter. And once you hear these names, you will never forget them. Death row is the last room at the end of a very long hallway. By the time someone reaches it, they have been arrested, tried, convicted, and sentenced to die. The legal system has, in theory, reviewed their case at multiple levels. Judges have signed off. Prosecutors have argued. Juries have deliberated. And yet, the 14 cases in this video share one devastating thread. In each of them, something emerged after conviction, sometimes hours before execution, that raised serious, documented, credible doubt about whether justice was being served or whether it was being performed. These are not fringe conspiracy theories. These are cases documented by journalists, law professors, innocence organizations, and, in some instances, by the courts themselves. 14 names, 14 stories, and a question that the justice system has never satisfactorily answered. What do you do when you might be killing the wrong person, and you do it anyway? Before we go any further, if this is the kind of content you've been looking for, you already know what to do. Hit subscribe right now. This channel covers the cases most channels won't touch with the depth they deserve. Don't be the person who finds this 2 years from now and wishes they'd been here from the start. Subscribe, turn on notifications, and let's continue. Case 1. Troy Davis. He walked to his death, telling the witnesses in the room, including the family of the man he was convicted of killing, that he did not do it. Troy Davis was a black man from Savannah, Georgia, convicted in 1991 of murdering off-duty police officer Mark McPhail outside a Burger King. McPhail had gone to help a homeless man being pistol-whipped in the parking lot. He was shot twice and killed. Davis was sentenced to death based almost entirely on eyewitness testimony. There was no physical evidence linking him to the crime. No murder weapon was ever found. But by the time his execution date arrived on September 21, 2011, 7 of the 9 non-police witnesses who had testified against him had recanted or contradicted their original statements. Several said they had been pressured by police. One witness, Sylvester "Red" Coles, the man who had originally pointed investigators toward Davis, was named by multiple recanting witnesses as the actual shooter. The case went to the U.S. Supreme Court.
It went back to a district court for an evidentiary hearing in 2010. The judge reviewed the recantations and ruled that Davis had not proven his innocence by a preponderance of evidence. The execution proceeded. The Georgia Board of Pardons and Paroles denied clemency. Protests erupted across the world. Pope Benedict XVI appealed for his life. Former President Jimmy Carter appealed for his life. Amnesty International called it one of the most high-profile execution cases in modern American history. At 11:08 p.m., Troy Davis was pronounced dead. He was 42 years old. 7 witnesses said they were wrong. The state said it didn't matter. And that was the end of Troy Davis.
Case 2. Cameron Todd Willingham. He was convicted of murdering his 3 daughters by setting his house on fire. He told police he tried to save them. He said the fire was an accident. The state of Texas said he was a monster. And on February 17, 2004, they executed him for it. Cameron Todd Willingham maintained his innocence from the moment of his arrest in 1991 until the moment he died by lethal injection. During his trial, fire investigators testified that the burn patterns in his Corsicana, Texas home were consistent with arson, that accelerant had been used, that the fire had multiple points of origin, that someone had deliberately set it. But before his execution, one of the country's leading fire scientists took a different view. Gerald Hurst, a Cambridge-educated fire investigator, reviewed the case evidence at the request of the Innocence Project and concluded that the indicators used to claim arson, including pour patterns, alligatoring of wood, and crazed glass, were scientifically invalid. Modern fire science had completely dismantled the methodology used to convict Willingham. Hurst submitted his report to the Texas Board of Pardons and Paroles and to Governor Rick Perry's office 4 days before the execution. Neither acted. After Willingham's death, the Texas Forensic Science Commission launched an investigation. Its own hired expert, Craig Byler, concluded in 2009 that the original investigators had no scientific basis for their arson finding and that the case did not even meet the fire investigation standards of the time. Governor Perry replaced 3 members of the commission days before Byler was scheduled to present his findings. There is no physical evidence that Cameron Todd Willingham committed arson. His daughters died in a fire. Whether it was set deliberately, we may never know for certain. What we do know is that the state of Texas had serious, documented scientific doubt in its hands, and it executed him anyway. Case 3. Carlos DeLuna. There were 2 men named Carlos in Corpus Christi, Texas, on the night of February 4, 1983. One of them was arrested at the scene, hiding under a car, wearing clean clothes on a night when a gas station clerk had just been stabbed to death in a brutal, blood-soaked struggle. That man was Carlos DeLuna. The other Carlos, Carlos Hernandez, was a violent felon with a documented history of knife attacks on women. Multiple people in the community knew him. Multiple people later said he had bragged about the killing. But the police found DeLuna first, and that was enough. DeLuna was convicted and sentenced to death on the testimony of a single eyewitness who identified him across a dark street from a distance. No blood, no forensic evidence, no weapon. From death row, DeLuna told anyone who would listen, "It was Carlos Hernandez. He did it. Look for him." Nobody looked. In 2004, 4 years after DeLuna's execution, Columbia Law School professor James Liebman led a team of students and investigators who spent years reconstructing the case. What they found was published in a 2012 Columbia Human Rights Law Review article that ran over 400 pages. Carlos Hernandez was real. He had an extensive criminal record. He had carried the exact type of knife used in the killing. Witnesses confirmed he had spoken about the crime. He had died in prison in 1999, 1 year before DeLuna was executed. Liebman's team concluded there was no credible evidence that Carlos DeLuna committed the murder, and substantial evidence pointing to Carlos Hernandez. The courts had Carlos DeLuna in custody. The right Carlos was never in the picture at all. He was executed in December 1989. He was 27 years old. 2 men named Carlos, 1 crime, 1 death row, 1 execution. And possibly, none of it had to happen. Case 4. Ruben Cantu. He was 16 years old when the crime was committed. Ruben Cantu was convicted of capital murder in San Antonio, Texas, for the 1984 shooting death of a man named Pedro Gomez during a robbery. A second man, Juan Moreno, was shot and survived. It was Moreno's identification that formed the backbone of the prosecution's case. There was no physical evidence, no murder weapon, no corroborating witnesses. Ruben Cantu was 17 at trial. He maintained his innocence throughout. He was executed on August 24, 1993. In 2005, 12 years after his death, the Houston Chronicle published an investigation that changed everything. Juan Moreno, the sole surviving eyewitness, gave a stunning interview. He said he had identified Cantu because he felt pressured to do so. He said he was not certain. He said, "The way police, were going, they were going to lock me up too." Moreno added, "I made a mistake." David Garza, the co-defendant who had pleaded guilty in the case and whose testimony helped seal Cantu's fate, also recanted. He told the Chronicle that he had lied to protect someone else and that Ruben Cantu was not present at the robbery. San Antonio's then police chief admitted the case deserved a second look. The district attorney at the time of the trial said, publicly, that he believed the wrong man had been convicted. An official investigation was opened. Ruben Cantu had been dead for 12 years. The only witness who could put him at the scene said he was wrong. The co-defendant said he wasn't there, and the state of Texas could not give him back a single day. Case 5. Claude Jones. Claude Jones was executed in Livingston, Texas on December 7, 2000. He was convicted of murdering a liquor store owner named Alan Hilzendegger during a robbery in 1989. The only physical evidence tying Jones to the crime was a single strand of hair found at the scene, a strand that a prosecution analyst testified belonged to Jones. Jones requested DNA testing of that hair before his execution. The request was denied. Governor George W. Bush had already left for Washington to prepare for his presidential transition. His successor, Rick Perry, allowed the execution to proceed without ordering the test. Jones died, insisting he was innocent. In 2010, the Innocence Project obtained the hair sample and had it tested using modern mitochondrial DNA analysis. The hair did not belong to Claude Jones. It belonged to the victim. The one and only piece of physical evidence used to tie Claude Jones to that murder was not his. Texas had the ability to test that hair before they killed him. The technology existed. The request had been made. Multiple courts and 2 governors had the opportunity to pause the process. They did not. Claude Jones was executed on the strength of a single strand of hair. That hair was not his. Think about that. Case 6. Larry Griffin. On June 26, 1980, a drug dealer named Quentin Moss was shot and killed on a street corner in St. Louis, Missouri. Police said it was a drive-by shooting. The car slowed down, a man leaned out, opened fire. Larry Griffin was convicted of that murder and executed on June 21, 1995. 15 years to the day of Moss's death. He maintained his innocence until the end. The conviction rested heavily on the testimony of Robert Fitzgerald, a career criminal who was in witness protection and who claimed to be an eyewitness at the scene. There was a problem. The first police officer to arrive at the scene, Officer Michael Reese, later said that Fitzgerald was not there when he arrived. Reese had not been called to testify at trial. His account, which contradicted the prosecution's star witness, had never been heard by a jury. Additionally, a man named Wallace Connors, who had been shot and wounded in the same attack that killed Quinton Moss, gave an interview years later stating that Griffin was not the shooter. Connors had also never been called to testify. In 2005, the NAACP Legal Defense Fund conducted an independent investigation. Their report concluded that there was no credible evidence Larry Griffin had committed the murder, and that the prosecution's case rested on the testimony of a single, demonstrably unreliable witness whose account contradicted the first responder on the scene. Larry Griffin's family has never stopped fighting for exoneration. The state of Missouri has never reopened the case. A first responder said the key witness wasn't there. A wounded survivor said Griffin wasn't the shooter. Neither man was ever called to testify. Case 7. Joseph Odell. Joseph Odell was executed in Virginia on July 23, 1997. He had been convicted of the 1985 rape and murder of Helen Shartner in Virginia Beach. The prosecution's case relied on blood and semen evidence, eyewitness testimony, and the statements of jailhouse informants who claimed Odell had confessed to them. Odell spent years fighting for DNA testing of the biological evidence, testing that could have conclusively confirmed or excluded him. Courts repeatedly denied the request. Virginia's then Attorney General argued that Odell had no constitutional right to post-conviction DNA testing. The European Parliament passed a resolution asking Virginia to delay the execution. Italy, where the abolitionist movement had made Odell's case a cause célèbre, held protests. The mayor of a town near Naples symbolically adopted him as a citizen. He was executed anyway. After his death, Odell's supporters continued pushing for testing of preserved evidence. In 1998, tests were conducted on some materials. The results were reported as inconclusive or not definitively exculpatory, but crucially, the full testing Odell had requested while alive was never completed before his death. What makes this case especially damning is not just what might have been found, it's the principle. A man facing death asked for a scientific test that might prove his innocence. The state said no. The machinery of execution moved forward. And whatever the truth was, it died with Joseph Odell on that table in Virginia. I want to stop here for one moment and ask you directly. After 7 cases, 7 men who asked for more time, more testing, more review, do you believe the American justice system can ever be trusted with the power of execution? Or is death simply too permanent for a system this fallible? Drop your answer in the comments right now. I read every single one, and I want to know what you think. Case 8. Leonel Herrera. Leonel Herrera was executed in Texas on May 12, 1993. He had been convicted of murdering 2 police officers, Officer Enrique Carrizales and Officer David Rucker, in 1981. The evidence against him was substantial. Eyewitness testimony, physical evidence, and the fact that a traffic stop victim identified him. He was sentenced to death. But in 1990, nearly a decade after his conviction, new affidavits surfaced. His nephew, Hector Villarreal, submitted a sworn statement claiming that Leonel's brother, Raul Herrera Sr., had confessed to committing the murders before his own death. A former state judge also submitted an affidavit supporting the claim that Raul was the true killer. A former cellmate of Raul's corroborated the story. Leonel Herrera took his case all the way to the United States Supreme Court, arguing that executing an innocent man would constitute cruel and unusual punishment under the Eighth Amendment. The Supreme Court, in Herrera v. Collins, 1993, ruled 6-3 that a freestanding claim of actual innocence, without a separate constitutional violation, was not sufficient grounds to halt an execution under federal habeas corpus. In plain language, even if you can prove you're innocent, that alone may not be enough to stop the state from killing you. Chief Justice Rehnquist, writing for the majority, suggested that clemency, not the courts, was the fail-safe for potentially innocent defendants. The Texas Board of Pardons and Paroles voted 9-3 against clemency. Leonel Herrera was executed 17 days after the Supreme Court ruling. His brother's alleged confession, a former judge's affidavit, a cellmate's testimony. The Supreme Court said, "Not enough." Texas said, "We're done talking." Case 9. Derek Rocco Barnabei. Derek Barnabei was executed in Virginia on September 14, 2000, for the 1993 rape and murder of Sarah Wisnowski, a college student and his former girlfriend. Barnabei insisted throughout that he was innocent. His defense team argued that the crime scene evidence pointed to a different perpetrator, and in the final months before his execution, they pushed hard for comprehensive DNA testing of biological material collected from the victim. Virginia resisted. Courts denied the requests. Governor Jim Gilmore declined to intervene. The case was notable for its international dimensions. Italy, which had abolished the death penalty decades earlier, made diplomatic representations on Barnabei's behalf. His Italian ancestry had made the case a flashpoint abroad, with the Italian government formally requesting a stay of execution. Virginia executed him anyway. Post-execution DNA analysis conducted at the request of advocacy groups on materials that were eventually tested produced results that Barnabei's supporters argued were consistent with an unknown third party, not Barnabei. Virginia disputed the interpretation of those results. What is not in dispute is this: the defense requested testing before the execution. Courts had the opportunity to order it. They declined. A man died, and the question of what that DNA evidence would have conclusively shown, if tested fully, transparently, before the execution, remains permanently, irreversibly open. Derek Barnabei was 29 years old. He asked for a test that might have answered the question. The answer came too late for him to hear it. Case 10. Johnny Frank Garrett. Johnny Frank Garrett was 17 years old when he was accused of raping and murdering the 76-year-old nun, Sister Tadea Benz, in Amarillo, Texas, in 1981. He was, by all clinical accounts, severely mentally ill. Psychiatrists who evaluated him documented horrific childhood abuse, serious psychological disorders, and intellectual limitations. His trial lasted a matter of days. His confession, the cornerstone of the prosecution's case, was challenged by his defense as coerced and unreliable. Garrett had a history of mental instability that made the validity of any statement he gave to investigators deeply questionable. He was convicted. He was sentenced to die. He was executed on February 11, 1992. His final words were a rambling, incoherent statement, widely cited as itself evidence of his profound mental illness. After his death, a man named Leoncio Rueda was convicted of a strikingly similar rape-murder of another elderly nun in the same area. Investigators and journalists later raised serious questions about whether Rueda, not Garrett, was responsible for Sister Benz's death as well. The DNA evidence in the case was limited, and Garrett's supporters argued the confession should never have been used. But what makes this case perhaps the most troubling of all is simple. A severely mentally ill teenager whose confession is disputed is executed. And a man who commits an eerily similar crime nearby is convicted years later, raising a question nobody in power wanted to seriously ask. Was Johnny Frank Garrett guilty? The state of Texas said yes, emphatically, fatally, and then moved on. Case 11. Shaka Sankofa, Gary Graham. Listed separately as Case 13, this entry covers Sankofa's unique legal battle. His name at birth was Gary Graham. He changed it to Shaka Sankofa while on death row, an act of self-reclamation in the face of a system he believed had already decided his fate. He was convicted of the 1981 murder of Bobby Lambert outside a Houston supermarket. He was 17 at the time of the crime. The case against him rested almost entirely on the testimony of a single eyewitness, Bernadine Skillern, who said she saw him commit the murder from 30 to 40 feet away through a car windshield at night. That was it. One witness. No physical evidence. No murder weapon recovered that was definitively linked to him. Two other witnesses present at the scene said the shooter was not Sankofa. They were never called by his original defense attorney, who many argued provided grossly inadequate representation. In the weeks and hours before his execution on June 22, 2000, his legal team filed emergency appeals. Civil rights leaders, including Reverend Jesse Jackson and Representative Sheila Jackson Lee, were physically present outside the Huntsville prison. The NAACP and Amnesty International called for a stay. The Texas Board of Pardons and Paroles voted against clemency. Governor George W. Bush declined to intervene. Sankofa was taken to the death chamber. He was strapped down. He shouted his innocence until he lost consciousness. One witness, 30 feet away, through glass, at night. That is what it took to kill Shaka Sankofa. Case 12. Carla Fay Tucker. The story of Carla Fay Tucker is unlike any other on this list, not because of the doubt about her guilt, but because of what her case revealed about who the system is willing to execute and why. Tucker was convicted of a horrific 1983 double murder in Houston, committed with a pickaxe during a drug-fueled break-in. She did not deny participation. By the time of her execution, she had spent 14 years on death row and had, by virtually every account, undergone a profound religious transformation. Prison chaplains, fellow inmates, corrections officers, international religious figures including Pope John Paul II, and broadcaster Pat Robertson all testified to the sincerity of her change and formally requested clemency. Before her execution, new testimony from witnesses and those who knew her confirmed that the woman who had committed the 1983 crime bore almost no resemblance to the woman in the cell. Texas executed her on February 3, 1998. She was the first woman executed in Texas since the Civil War. Governor Bush, when asked in a television interview whether he had considered her plea for mercy, was caught apparently mocking her voice and demeanor. He later said that was mischaracterized. The Clemency Board voted unanimously against her. The question her case forces into the room is uncomfortable. If a justice system believes in rehabilitation, if it holds that people can change, what does it mean to execute someone whose transformation is beyond dispute? Carla Fay Tucker did not claim innocence. She claimed to be a different person. Texas said it didn't matter. Case 13. Gary Graham. The science of eyewitness identification had, by the year 2000, accumulated decades of research pointing to a disturbing truth. Human memory is not a recording. It is a reconstruction. And reconstructions fail. Studies conducted by psychologists, including Dr. Elizabeth Loftus, had demonstrated repeatedly that eyewitness identifications, particularly those made across distance, in low light, through obstructions, or under emotional stress, are among the least reliable forms of evidence in criminal prosecution. Yet, in the case of Gary Graham, a single eyewitness identification, made at night from 30 to 40 feet through a car windshield, was sufficient to send a man to death. The two witnesses who could have contradicted Bernadine Skillern's account were never heard by the jury. His defense attorney, who reportedly spent minimal time preparing the case, had not called them. In the years before Graham's execution, legal advocates filed documentation challenging the eyewitness identification methodology used in the case, the adequacy of his legal representation, and his age at the time of the offense. Every court that reviewed those arguments denied relief. The day he was executed, legal teams were still filing motions. Eyewitness error is the leading contributing factor in wrongful convictions that have been overturned by DNA evidence, according to the Innocence Project's data. Gary Graham was convicted by an eyewitness. He was executed by a system that decided that was enough. Case 14. Cameron Todd Willingham, The Fire Science. We return to Cameron Todd Willingham because his case does not end with the question of whether the state listened. It continues into the question of what the state knew. When the Corsicana Fire Department investigated the February 1991 fire that killed his 3 daughters, they applied a set of fire investigation principles that had dominated the field for decades. Burn patterns in V-shapes, pour patterns, alligatoring of wood, crazed glass, low burn lines. These were treated as reliable indicators that accelerant had been used, that someone had poured something flammable and lit a match. But the field of fire science underwent a revolution in the 1990s and 2000s. Controlled burn experiments, conducted in laboratories and real structures by organizations including the National Fire Protection Association, demonstrated that almost every indicator used to convict Willingham could and did occur in accidental fires under the right conditions. Alligatoring? Caused by heat intensity and duration, not necessarily accelerant. Crazed glass? Once thought to be caused exclusively by rapid temperature change from accelerants, now known to result from rapid firefighting water contact. Multiple origin points? A fast-moving accidental fire can produce exactly the same burn patterns. Gerald Hurst said it in 2004. Craig Byler said it in 2009. The Texas Forensic Science Commission's own investigation confirmed it. The men who testified against Willingham at trial were not lying. They believed what they were saying. They were applying the tools of their training, but their training was wrong. And a man was executed for a fire that may never have been a crime at all. 3 little girls died. Their father died too, killed by a system that thought it knew what a guilty fire looked like. It didn't. If these 14 stories moved you, if they angered you, disturbed you, or made you question what you think you know about justice, then you already understand why this channel exists. We are here to tell the stories that fall through the cracks of the official record, the names that get buried, the evidence that surfaces too late, the questions that powerful people would rather you not ask. There are hundreds more stories where these came from. Cases that never made international headlines. Men and women who had no protesters outside their prison walls. No papal appeals. No viral petitions. Just a needle and silence. If you are not subscribed yet, do it now. Turn on notifications, because the next video is already coming. And I promise you, you will not be able to look away. This is the kind of content that matters. Stay with us. 14 names, 14 cases where doubt existed, documented, credible, human doubt, and the machinery of execution moved forward anyway. Some of these men may have been guilty. Some almost certainly were not. The tragedy is that in a system built on the principle that it is better to let 10 guilty men go free than to execute one innocent, we may have done exactly the opposite. Execution is unique among all punishments. It cannot be appealed from the grave. It cannot be reversed by a governor's pardon. It cannot be compensated by a settlement or a tearful apology in a courtroom 20 years later. When the state executes a person, it makes a claim so absolute, so irreversible, so final, that it had better be right. These 14 cases suggest that it might not have been. And somewhere, right now, there is a person on death row, filing appeals, writing letters, asking for tests, claiming innocence, whose story may one day appear on a list just like this one. The question is not whether the justice system intends to get it right. The question is whether intention is enough when the consequence of being wrong is this permanent. Remember these names: Troy Davis, Cameron Todd Willingham, Carlos DeLuna, Ruben Cantu, Claude Jones, Larry Griffin, Joseph Odell, Leonel Herrera, Derek Barnabei, Johnny Frank Garrett, Shaka Sankofa, Carla Fay Tucker, Gary Graham. Remember them, because the system already has.